Peace be upon you. Hello. Hello.
And we have a huge outside. We people
Your
arrived.
brother. In the name of Allah, the most gracious, the most merciful. Greetings. This is Advocate Avros Rajbot. As you all know, we have started a lecture series on the juvenile justice system. Eating Taoism is a requirement, and today we are quite late. There was a major issue with the internet, so sorry for that. How to show love for them. Starting immediately with a broad leak. We have had 3 lectures. Today's lecture is our 4th, and today we will talk about juvenile bail and its investigation. Gibran's sister system is like 2018, as I have already told you. Companion will apply. It happens when Ahmadiyya passes, meaning the same day it passed. So at that time, it was applied and enforced. It became enforced in accordance with the law of Pakistan. Pakistan and what stages it has gone through, I have already told you people in the first lecture. It's not the first time whenever there's an offense. Even then, our criminal procedure becomes active when oxidation occurs, which means whenever we say that the starting of criminal pieces is with us.
Good. Show like.
Mark any file, let's go. After an offense, an FIR is lodged under Section 154 CRPC, following which any person can be arrested. Got poisoned, they say. So the one named also says if they are performing juvenile and admits I am juvenile, then the Juvenile Justice System Act of 2018 will be applied here. And its Section 8 will be applied first, which deals with the inquiry. Who will conduct the inquiry? Whose inquiry will it be? There will be an inquiry of juvenile age. Whoever conducts the inquiry has the evidence. They are with our station house officer who has the evidence. And those who have come, meaning the investigation officers, they are all sub-inspectors, should not be less than the level, meaning the sub-inspector himself. The case, the one who deals with it. So here comes the question, what will the inquiry include? Number 1, birth certificate to see if juvenile or not. I've already discussed Angel's agenda today. That fewer days
will be 18
that which will be called a vignette. Wherever it is seen, it rains whistles on the cricket pitch. Rains whistles on the cricket pitch. If you think you have been armed, investigation officer, well then there they will check his educational documents belonging to the youth pool of Ingard. If that does not satisfy, a third option is given to consult other pertinent documents that we have. Your sin has been cut. If a CNIC is made, then it will also be revealed from here that he is not a juvenile, but also an adult person. Finally, the 4th option we have.
She saw that as a medical examiner.
Nations.
And the same.
This is our amended section, which was not present in the JJ Act, meaning the ordinance, but it has been amended. The juvenile justice system will have a medical examination done in 2018. When it is proven from here that the person who is arrested, what is the video?
Built then?
What will be placed first now will be with its guardian.
Could be its guardian, could be its parents.
They will be contacted, they will be called, and here first Juvenile Justice System Committee, which I have already given you the first lecture on. They will be involved in it, including the people who will be inside. I will tell you again who can be there. Is number 1. Either a district magistrate will deal with this under section 30 or a first-class magistrate will be the DD, the district public prosecutor.
We will go companion.
The advocate handling this should have at least 7 years of standing, meaning the advocate needs to have practiced for 7 years. The cases of juvenile, along with this, there will be a probation officer present. These 4 people are with us. They will be present, not less than grade 17. There will be probation. This Juvenile Justice Committee is concerned by the victim's concerns and by the consent of the accused, meaning that youthful offenders who are juvenile will be taken towards diversion. In diversion, we have things available. Either apologize to the child who is juvenile.
Even the police.
This character can count for the division, or else she can call the committee section 399. The Justice System Act mentions that the committees present here shall be seated, or the police can opt for diversion on their own. Diversion.
Audio.
Certainly, an apology can be made, meaning all punishments have this option. Any damages suffered by the victim can be compensated for if it's a case related to property and there has been an issue with the property. The cost of the mattress or its fine can also be compensated along with the community center, which is not yet established in Pakistan. The concept of community centers, community services are given as a punishment to juveniles.
In times of
In
scarcity.
any institution, sending it is dealt with in a way similar to a job. For example, any ticket, it gives somewhere in the house.
Then you can apply there as well.
Or if there's cleaning work, they can be assigned to clean, indicating all punishments allow for this.
We'll ask for community services.
There is no diversion in Pakistan yet, but because it is written in the Juvenile Justice System Act, I am explaining it to you. The second thing is that they should be kept in a rehabilitation center because you simply cannot keep a juvenile in jail. The time for diversion here is basically 1 month if the diversion occurs with the consent of the accused and the victim's party.
And if they
Simply
diverge,
hot
then
metal to
Here the report is presented before even entering the port. The juveniles matter is closed here. As I had told you earlier, their identity
what exists
does
can
not
be
do
done.
flowers.
And
If someone does this, they will be punished. Here we will discuss the bill sections we had come up to arrest and the inquiry after the arrest. Inquiries such as these left by eyes that were no less than sub-inspector level. Now it's clear here after the juvenile, we've contacted the Justice Committee. The police initiated a diversion. If the matters are resolved with diversion, they become the way forward now is if it's a very beautiful favor.
victim party.
I don't believe there are such issues. Then we'll go to court now. When
we come here,
it's discussed which code will deal with juveniles. So a separate code for juveniles has been made in the Juvenile Justice System Act regarding their matters. Deals with when we talk about offenses, whether practicing in the criminal side or discussing some black aspect. We all know when the offense, when it comes to it, it will be discussed first. When there are liabilities or punishments, then these are the general provisions we have since we deal with it. When one enters the court, then what happens in the court, it becomes their responsibility to check the juvenile's previous record to see if they are Hugh or Carmelainer. Provision is a provision officer who, along with checking the provided record, will include what things in it. First, their character certificate will be checked. Secondly, their educational background will be verified. Thirdly, social criteria will be checked. Whether he has been a first offender, his activities before, whether he was involved in criminal activities or it happened by mistake. Then we have this that once all these things are checked, that the responsibility to provide legal services from the option officer. The juvenile is what our government has. It will provide for our government, as told here. Juvenile Justice System Act 2018, whatever it is. The lawyer who will deal this is at the 7 years bar.
Thank you very much.
They should be, meaning 7 years of
They have to go through
lawyers with
inspection.
less than 7 years of practice cannot deal with juvenile matters. Here, when the matter comes to the meter running, after sifting through the meter, our juvenile trials have now started. Here, juveniles are also provided with legal services following an amendment to the juvenile trial. As I told you, even when you arrest in divergences, you can go towards divergence. There, why is odd too? It is also the court's responsibility to make an effort to solve the issue with the first divergence. Now, what we didn't have before in our JJ Act has now been commanded in the ordinances is that juveniles, judge in this section or the first class magistrate will deal with it, which is under section 302 of the CRPC we have, which can give us up to 7 years of punishment, will be dealt with. And the courts were told by the Juvenile Justice System Act that when you conduct a trial for a juvenile, then it should be completed within 6 months. If it's above 6 months, then it's wrong.
When in
It would
need.
also be wrong for binary because this child has to continue their education ahead. If the child has made a mistake, they have to face it in society too. Therefore, its identity has not been disclosed, but a time period has also been mentioned here that within 6 months, who are our forefathers, who are from child code, who are from Banyals, if at the time of trial, if the matter goes towards diversion, it will be solved. And then the magistrate who has the matter with him, which we have in court, very good grounds, will let go, will activate, and this matter will end right here. This power, these are the court's dispersions that if they wish, they can also impose burden on Jalal Ali, meaning that pay a lot of respect. Now let's turn to bills. Will juveniles get bail? It might be possible. We all know that Section 6 is dealing with the bails. There are two types of bails, bailable offenses and non-bailable offenses. You are here for juveniles. A leniency is given where it is mentioned that if there are bailable offenses, it talks about major and minor, not about bailable and non-bailable. In the Juvenile Justice System Act it is mentioned that there are two categories defined here, minor and major, which I will explain to you as number one. One has been made.
Which is less than 16 years.
How will it be given? And one juvenile who is less than 18, 16 to 17 years old is still considered a juvenile. Caught in conflict, survived, he did that. Will it be dealt from the breast? Will they get bail or not? In number one item, 496 CRPC deals with all bailable offenses where bail is given for all those offenses that are bailable. In this case, bail will necessarily be granted.
But Liz became 16.
The juggler we have with us,
They blend the light within
it
the
is
heart.
given that sentences up to 10 years are dealt with under Section 97 CRPC. It was also stated there that juveniles must be granted bail, but not for non-bailable
That means
offenses.
even in fences.
Juvenile bail, these are necessarily concluded because we are going to juggernaut, can never be kept in gene. It could affect their mental and physical health, and they might struggle to face society, feel fear. So in non-bailable cases, bail will also be granted up to 10 years.
Next
In this
punishment.
too, bail will be given to the juvenile, which is mandatory. If someone is mature, now here we are talking about that. The categories that fall under 16, 17 are those of emails. Can Azabil also be given in this or not? Absolutely can be given, but here the discretion of the court also exists. Can the bail of any juvenile be rejected? There's a possibility to reject the bail of any juvenile. We have our juvenile courts. If a court desires, bail rejection can increase, but for what reasons will it be rejected? There is only one reason. Bail reviews
It will be
jockey.
given based on what they do.
It will go that if this structure is given a bull and it is at risk of its life from the victim's family, or there's a risk to our society if these criminals are granted bail and then commit more crimes. Habitual offenders will be included because in such cases we see that brainwashing children can be done quite easily. People who brainwash children are all considered criminals when any crime is committed. Even in prison, there are such hard criminals present, hence the prison's prohibition. Secondly, if outside there is a threat that he will go and meet those people, then there is the problem of victims' family fearing for their life from consequences. Your videos can also be hijacked. But where will you keep it after rejecting the bail? Because you can't keep it in jail. You're being told either this or that. The guardian of the juvenile will take the responsibility to keep them in their custody. Will we still have reformation houses available here in Pakistan? Or there will be borstal houses where they will be kept, where they will also be provided with education, and the government has taken the responsibility of their better upbringing. Like those who, there are reformation centers or rehabilitation centers where those who are sinful will be kept. If we talk about it, your family has already been prohibited from apprehending the female juvenile, meaning the female juvenile is off limits to you. Cannot do, and neither it with the male provision officer, you can become part of the investigation with him. It will be placed where the female probation officer will deal with it. And where there are females, there will be a female juvenile. It will be dealt with. Arrest of a juvenile or dealing with an arrest of a juvenile is referred to as Section 5. When arrested, have I already told you in the petition lecture what happens? They will not be handcuffed there, and they will not be dealt with as if he is a criminal that we deal with as adults. It's important to mention one thing here regarding your section 203. The juvenile justice system of 2018 discusses overriding concerns about laws being overridden. What is the purpose of overriding? The meaning of overriding is, since this is a special act, a special law, everything will be dealt with under it. But if we talk about GJS, we say 25. If this section has been repealed, then who is it being enforced on besides this law? Overrides for Win 9X, which are being overwritten by Win 9X rests Storm 2080. What is this overriding? Because JJ has already repeated this for us. We know that Section 299B of the IPC and Section 3655C of the IPCA both address governance. The juvenile justice system overrides it because in the Criminal Procedure Code, Section 29, if we look, it tells us which magistrate will deal with it. There it is written that a first-class magistrate will deal with it. The age of juveniles mentioned in Section 399 of the Criminal Procedure Code is specified as 15 years. As I've stated before, in the context of Pakistan, there has been quite a debate regarding the ages. So to make it easier, I've told you that under 18 South, he will be called your juvenile. He will be 15 years old, which is the age dealt for juveniles. Section 399 pertains to the rights within the juvenile justice system. Section 2, which shows how the youthful offender, the juvenile, will be determined by age. I have clarified these things for you here. Their guardian will also come. We discussed the normal bells, that if someone is an adult, they are dealt with like adults, but because we are talking about juveniles here, so here you have the jail system. He will be dealt with in a juvenile court if he is a juvenile. And looking at the records for the entire kingdom, including those magistrates who have remained loyal to the child lineage. At the stage of trial, if there are diversions, the case will still be closed. If this doesn't happen and filtration continues, even then what will happen, our magistrate has the power to pardon the Nayas if they wish. Now, if the Nayas are side upon, they are not kept in prison if they are sentenced. For this, there are reformation centers. For this, you have rehabilitation centers. Many organizations are working on this, and if they are working on juveniles, the government can also grant them licenses, or the guardian will be for this purpose. The state is responsible for the security of the juvenile and will retain custody. This has also happened. We have dealt with the bills, dealt with the investigation, who can and cannot conduct investigations on juveniles. We have seen in the non-B legal that leniency is maintained for juveniles. We observe the time period during their trial. The juvenile's identity was preserved from the commitment until the end of the trial.
Absolutely forbidden to disclose. Keep it a secret.
Fame's gone and then to twilight.
Any punishment received is to the extent that it's for 3 years, but even for that, they cannot be imprisoned or punished. And she rehabilitated her mental health, her education, everything to make her a responsible, good citizen of Pakistan. Any performance is for this purpose from our General Justice Committee. The Juvenile Justice Committee also goes to places to inspect whether these children are being made to labor or if they are being punished. The punishments for juveniles do not include hard labor, nor are they given simple labor. It means they cannot be made to work, they cannot be handcuffed, they cannot be shackled, they cannot be kept with other adult offenders. And with them, it's about adopting a gentle approach, which we've been ethically taught that we have to deal with them just so as he is a child and will be dealt with exactly as a child should be. You can't opt for hard punishments, hard labor, or even simple labor beyond this. Now, juvenile is classified into undesignated and designated offenses, with the undesignated being offenses without labels. Even the word already and qualify remain the same in our normal procedure if we look at the CRTC. So in 496, if there is a bailable offense, then he gets bail. But if it's a non-bailable offense, then bail cannot be given there. If there is a 10-year sentence, it happens in our procedure class. In the procedure class, to get bails, you need to provide arguments, give reasons, but a non-bailable is certain. Those who are guilty have this leniency available. If someone has been convicted of a crime that carries a sentence of more than 10 years and falls under the probationary clause, they should still be granted bail. Will be a probation officer. They will be with someone who is not less than grade 17, either a guardian or a rehabilitation center will be available to you or those we currently have. Now you can request an apology from the juvenile. By returning an apology, you can resolve the matter and display identity. People cannot move. Whenever the trial runs in court, the court is also told when honorable courts try juveniles, there will be juveniles present. Besides the victim party, there will be no third person present. This identity is so significant that even in the media, juvenile cases are discussed. There will be no such thing done, nor will it be tried in the media. Remember, we talked about juvenile as beings during the investigation. Which courts will deal with this was also discussed. And today's lecture ends here because it is a minor act, not a major one. And we are dividing this into parts so that you all can easily understand. So today we have ended our lecture, and if there are any questions, feel free to ask. If we don't have any questions, we just look up the lecture like this. Take care of yourself, and God willing, we will be present in your esteemed company next week with the next lecture. Until then, goodbye.